Welcome back to our State of the Nation discussion. We are having a post-analysis of the full verdict as delivered by the Supreme Court yesterday. In studio for this conversation, Honorable Anthony Olwach, Member of Parliament, Mathare constituency, and Honorable Jeremiah Kioni, Member of Parliament, Ndaragwa constituency. Gentlemen, many thanks for staying on. Just before we took a break, we were looking, just about to look at the dissenting opinions given by Lady Justice Njoki Ndung'u and Jackton Ojwang. But perhaps the most comprehensive and most compelling judgment was one by Njoki Ndung'u, who repeated time and time again that the will of the voter is supreme in the absence of evidence, and a court must not interfere with the people's choice. Something similar to what Jackton Ojwang said. He says there was not enough evidence to nullify the election and subvert the will of the people. But a press statement here detailing the ruling by Justice Njoki Ndung'u, she faults the majority on several things. Let's take a look at them one by one. One of them was not using certified forms filed in court by the IEBC to verify the allegations made by Raila Odinga. Honorable Olwach, the court is meant to use all the evidence presented before it in determining this petition. Your thoughts on this fault?
First of all, I want to say two things. When the court ordered scrutiny, it directed that the registrar, under the supervision of staff that were going to be appointed, and persons and experts from both parties, go and get access to Form 34s. This process was done at Milimani. Forms that were brought by IEBC. They were not brought by NASA. They were not brought by Jubilee. Those forms were brought by IEBC. The analysis by the registrar was an analysis based on those forms. And this is where the point lies, really, that people are not getting. When the analysis was being done prior to the filing of the petition, we discovered two things. The forms that were availed to our agents at Bomas of Kenya were different in terms of Form 34A, B, and C. They were different from the forms that you found on their portal. And then a further analysis of what they had on their portal and with what they put or deposited in the Supreme Court were different. And then the forms that they gave us under the supervision of the registrar, again, are different. So what that does tell you, IEBC had almost 3 or 4 set of varying Form 34Bs and Form 34Cs. So what does Njoki Ndung'u do? Njoki Ndung'u does something that is extremely strange. She departs from a report that was ordered by the court, adopted by the court, parties given 10 minutes each to comment on it, and during the pendency of the hearing, she did not question those things. Then she carries out a post-judgment analysis on her own, which she can do, but under what parameters? She ought to have involved the registrar. She ought to have involved other people so that we know what is she examining. She's examining documents that we are already saying have shifted 3 times. When she was looking at court-deposited document, she should have looked at what they put for us in the portal, which we annexed. She should have looked at what they put at Milimani, which was brought by IEBC itself, which creates another narrative. When she puts her own analysis and says, Kisauni is okay, this one is okay, this one is okay, she is looking at one narrative. There were 4 different narratives coming from the one IEBC. She ought to have looked at all this before she gave a clean bill of health to IEBC.
Honorable Kioni, if that was true, that's a major illegality on the part of the IEBC, isn't it?
All that you need to do is arrange, and then the court puts the burden on the other person to prove. Raila or NASA alleged that the forms were not proper. The court did not find it necessary to use the certified forms filed by IEBC to check that allegation. That is one of the reasons why there's a dissenting voice. And what Njoki Ndung'u did, which I think is a good thing to have done, if you are not, let me not use the word I wanted to say, if you really want to do that work thoroughly, is you go back to the evidence given and the documents given to you by the parties, and you sit and scrutinize them so that you can be able to come up with a decision. And that is what the other judges did not do. There were specific constituencies that were mentioned where the forms had problems. If those constituencies had been picked as samples, it was still necessary for the judges to use the same sampled constituency to verify whether what was being alleged was true. And those were the constituencies of Kisauni, Likoni, Mwandera, and Isiolo, and I think 1 or 2, 3, 4 others. And this is what Joe Gidongo did. He went specifically to those constituencies, picked the forms as filed by IEBC, and checked on the allegations that NASA was making, and he could tell that it is not true. These are just allegations, and they were inaccurate, because the forms were here, signed by the agents from NASA, signed by the returning officers, and containing the results, which were not being disputed. So that is one of the things that you cannot then say that it was a mistake for Joe Gidongo to have gone to that extra mile. It was necessary for her and every other judge to do the same so that we get to know the truth. You can't nullify
a whole
the
election.
we of 15 million people with just because you don't want to go back and check on those particular specific allegations.
All right, and so the two dissenting judges there say that instead we should have had a recount of these votes. And this is another fault that Joe Gidongo has on the majority decision. She says that the majority assumed that since there were more votes cast in favor of the president compared to governors and members of parliament, that IEBC had interfered with the result of the presidential elections. She, however, informs the majority that the law does allow a voter to cast only one ballot, so long as the unused ballots were kept aside in a tamper-proof envelope. A voter is not under any obligation to vote for all the 6 candidates in an election. And even as you get your thoughts on this, in just a moment we'll be listening to Chief Justice David Maraga on what he had to say on the vote counting issue in terms of quality over quantity. But Honorable Oluwatch, was this a fault in the part of the majority, assuming that every voter voted for all six elections, really?
I think we must look at it in terms of context and practice. When a voter walks to the polling booth, you are given 6 ballot papers. So let me take you back to the question of Justice Philomena Mwilu during the hearing. You have no obligation. Nobody puts a gun on your head and says, tick on the 6. But this $1 million question is, you got 6 ballots. It's not a shop where you say, me, I want this and not this. They pluck 6, they give you. Justice Philomena Mwilu's question has gone unanswered to date. Where do you take the other 5? And the reason this is crucial...
she says here, in tamper-proof envelopes.
There is no demonstration. Remember, we put up a case which went unanswered. It was asked before the entire viewing of the nation. Right. Where did these things go? And what Mwilu wanted is just direct us to where the unmarked ballot papers went. There was no answer to that. So there is no question here that you do not have to nini. Okay, fine, show us where these went. Remember in 2013, an allegation IEBC has never cleared to date. 2 million people walked to the polling booth and only voted to the president. We must look at mischief. It is not possible that 2 million people just wanted to just show me where the president is, tick and then move on. So I think it is without basis, it is without foundation that Justice Joe Gidongo would say that, you know, nobody says you must vote. Fine, show us the remains, because we have the rejected votes and they're here.
Honorable Kioni, he does have a point in terms of these ballot papers unused, kept aside in tamper-proof evidence. Has that evidence been provided of unmarked ballot papers?
And remember, the burden shifts. We already alleged the burden now shifts. Let us be shown where is the box where the other ballot or the unmarked ballot papers are. The burden shifts.
How else will you have been able to demonstrate that other than going for a recount?
Did you request for the recount?
Were we going to request? We are not the petitioners. You are the petitioners.
You can do that.
The court found it necessary to ask for all other forms of scrutiny other than the ballot that was cast and is still sealed in that ballot box. How else? What else? How do you even expect IEBC to direct voters that if you get 6 in the coming elections, in the 17, well, fortunately 17 is just one ballot. If we were to do the elections all over again, what would you want IEBC to do with the other 5? What would you want them? It's my will. I want to walk in the polling station and vote for only one person.
Every ballot must be accounted for.
Yes,
that's a requirement
and the way,
of law.
When you have an issue with that, allow for the recount. Why is it that it's becoming difficult?
But
for you
the
to allow for that
petitioner
recount?
is entitled to decide whether to go for recount, to go for scrutiny, to go for nullification. You can choose either.
And you
we chose to go the process of
Let's listen in to what Chief Justice David Maraga had to say on this recounting issue, because he had an issue as to whether we should focus more on quality over quantity. Let's listen in.
True that where the quantitative difference in numbers is negligible, the court, as we were urged, should not disturb the election. But what if the numbers are themselves a product not of the expression of the free and the sovereign will of the people, but of many unanswered questions with which we are faced? In such a critical process as the election of the president, isn't quality just as important as quantity? In the face of all these troubling questions, would this court, even in the absence of a finding of violations of the Constitution and the law, have confidence to lend legitimacy to this election? Would an election observer, having given clean bill of health to this election on the basis of what he or she saw on the voting day, stand by his or her verdict when confronted with these imponderables? It is to the Kenyan voter that a man or a woman who wakes up at 3 a.m. on voting day, carrying with him or her the promise of the Constitution to brave the vicissitudes of nature in order to cast his or her vote.
IEBC behaved as though the provisions of sections 39, 44 and 44A of the Elections Act did not exist. IEBC behaved as though the provisions of Article 88(5) of the Constitution, requiring it to, quote, exercise its powers and perform its functions in accordance with the Constitution and national legislation, quote, unquote, did not exist. IEBC failed to observe the mandatory provisions of Article 86 of the Constitution, requiring it to conduct the elections in a simple, accurate, verifiable, secure, accountable, transparent manner. Where is transparency or verifiability when IEBC, contrary to Articles 35 and 47 of our Constitution, was still in the contumacious disobedience of this court's order, refuses to open its servers and logs for inspection? Having therefore carefully considered all the affidavit evidence and submissions of counsel for all the parties, we find and hold that the petitioners herein have discharged the legal burden of proving that the second respondent declared the final results for the election of the president before the first respondent had received all the results from Forms 34A from all the 40,883 polling stations, contrary to the Constitution and to the applicable law. We also find and hold that the second respondent declared the said results solely on the basis of Forms 34B, some of which were of dubious authenticity. We further find that the first respondent, in disregard of the provisions of Section 39(1)(c) of the Elections Act, either failed or neglected to electronically transmit in the prescribed form the tabulated results of an election of the president from many polling stations to the National Tallying Center. It has been established.
All right, so that is Deputy Chief Justice Philomena Mwilu there reiterating a few of the issues they found on the part of the IEBC. But let's first focus on what Chief Justice David Maraga had to say. And I'd pose that question to you, Honorable Kioni. Chief Justice David Maraga asks, isn't the quantity of the papers in the ballot boxes just as important as the quality of the entire process?
The quantity of the ballot papers in the ballot box is very important, just as is important with the process. I agree, but why didn't we find out on the quantity so that we can make judgment on both? Why elevate one process above the other? That's my question.
All right.
Okay, I think the point that I want to make here in respect of that is this. It is entirely possible that if all the procedures and processes were strictly followed, the result and the count would be totally different from what was declared. So the question then that we must ask is that who would be the beneficiary of a failure or refusal to follow the process? It is the person that is being alleged to have won. And that's where really the point here is. If we don't want these processes, and form doesn't matter, and Jokin Dungu made a very compelling argument. For jurisprudential reasons, our arguments were very potent. But then the question that we must pose is that if process and form does not matter, why don't we just go to the Moi days of Mulolongo? Really, process there was not important. Just line up, and with your naked eyes, you could see that Michelle has the longest line. So you don't need forms, you don't need transmission, you don't need anything. But because we put these processes, the two must be married in order to have the result. And that's what Milu was saying, that when you're given a mathematical problem, you're given a formula to follow. You're not told, you go and decide how this answer is arrived at. You will be marked on half of the count of the total based on how did you work out the formula. It constitutes 50%. So if process constitutes 50% of our election, 50% of this election was fraudulent. If 50% is fraudulent because of failure to follow process, how can the result count?
Right,
that's the point.
The process would be worrying me if when the voter woke up to go and vote, getting to the polling station, the polling stations were not opened. The ballot papers were not there. The clerks had not reported on time. The ballot station, the polling station was closed 3 hours before. The counting was done in some secluded manner. That would worry me. But for as long as the voter expressed his will, and his will is still imprisoned in a ballot box sealed somewhere, this other process, you are allowing it, you know, we are allowing ourselves, you're saying the form was not stamped by an employee who can choose not to stamp for one reason or other, or even may just fail to stamp. The form was not signed, and the person who is expected to sign is an agent of my opponent. And it happens even in our own constituencies. So when you now tell me that we are going to continue nullifying elections in this country on account on errors, some of them deliberate, by people employed to do their work, that will always pose a big problem. And I want to say this, and I think we should also not be so hypocritical. If this thing was long at the presidential, if this whole process, the transmission and the process were long, it was long for the presidential vote, it was wrong for the member of parliament vote, it was wrong for all of us.
And it's good that you bring
in
that
essence,
up.
what we are actually saying is that perhaps what the Supreme Court was short of saying is that all of you go back.
Go back to that. It's great that you bring that point up because we need to advance this conversation. We don't have much time left. So as it is, Jubilee has of course asked that the contents of the ballot boxes be preserved, as is of course stipulated in law. But if we're arguing that the quality is just as important as the quantity, are we talking of preserving just the ballot papers or every other device used in the entire electoral system? Because as it is, we have several petitions. Case in point, Embu, where former Senator Lenny Kivuti had been directed or had gone to court, and the court had issued IBC with orders to provide those KIEMS kits. Now, many of these petitions will need those KIEMS kits in prosecuting their petitions, but IBC, in preparing for the repeat presidential election, says it needs these kits to upgrade them, which therefore means much of that information will be lost and will no longer be used in the prosecution of these petitions. Honorable Olwach, how is this likely to play out, and does this mean then that Safra and Mofo, if it is conducting this election, will need to procure completely new kits?
Precisely the point. The KIEMS kits now form part of what you call election material. Election material is not just the ballot boxes and ballot papers. Anything that was used in the entire process, including the seals, they form part of election materials.
Right.
So it is incumbent, I think, upon the IEBC not only to preserve the ballots and the papers, but the KIMS kits. Because remember, the problem here, like he says, that there was no problem queuing, voting. The actual place was in transmission. Now, the KIMS kit, this is the way it was designed under the Kenya Integrated Election Management Systems. That it is the KIMS kit incorporates the voter registration, voting itself, identification, and then results transmission. So it is not possible to deconstruct and put a compartment in the schemes and say, we will carry out the fresh presidential election and not interfere with the rest of the KIMS kit. That is why IEBC and whoever it is that procure these KIMS kits must begin to think about alternative KIMS. These are still part of the election material, which even if you leave out the governor positions, they're required to be preserved for 3 years. But they are positioned, and I want to deconstruct the idea that because we have impugned the presidential election, they had numbers in governors and all that. The challenge to the presidential election is under Article 140, and you can only challenge the presidential election. Remember, it was term-bound. You file within 7 days, it is heard within 14 days. The question of governorship, senatorship, MP has only just begun. When the chips fall, and the 6-month period for the hearing of all these positions is over, it is very possible that a lot of seats will fall in the same manner the presidential election fell.
Honorable Kione, so this controversial firm, Safran, already had indicated that it may not be able to meet the October 17th deadline if it is to upgrade the KIMS systems that were used in the previous election. But this now coming into play, and these KIMS kits now being looked at as part of election materials that they may need to have been stored together with the ballot boxes. What are your thoughts in terms of the next, in terms of the transmission of results and the company to manage this?
Just a step back before I come to that, is that I think this is what was in the minds of the senior counsel, Mwite, when he was saying, but the record is in that petition. Why we both had been preserving these numbers in the ballot boxes, and the courts will never be interested in counting them or looking at who voted and where did you vote and what was the usefulness of your will.
What about the petitions that are being filed?
I'm coming to that. I think that is what would quickly come to your mind and say, then why preserve this thing for 3 years? Why don't you just ban them? In any case, you've told us the process is more important than counting the ballots. But I think it is important that that aspect be looked into, because it is something that will come into play. This KIMS kit will need to be used. And if it needs to be used, it must go through a process of perhaps screening.
Right.
And I think we have to leave IEBC to do the management. We should avoid micromanaging them. Let them manage the process. We have only 40 days within which to do the presidential election.
All right. And of course,
if they need to get another set of things, and it is possible for them to do it, we will need to allow them to manage it. For as long as we are seen to be the one managing them as politicians, you create suspicion.
All right, and of course a lot of reactions
And I think we just have to allow them to manage it, because if it becomes necessary for them to even, like yesterday, I think the direction was that procure new ballot boxes. You're not going to touch these ones. Even if we have said we will never recount those presidential ballots, they don't make any sense, they can be eaten by the rats. I mean, the thing is that I would be happier to see IEBC themselves managing that process and saying, for this reason, we are doing 1, 2, 3, 4 things.
Right.
But if we try to micromanage them and try to drive them to a situation where we get into a constitutional crisis, that's where the problem will be.
Right, I don't know if you'd call it micromanaging, but there were several reactions by opposition leaders outside the Supreme Court yesterday with regard to the issues that had been pointed out about the Supreme Court on the part of the IEBC. Let's listen in to what NASA leader Raila Odinga and his lead counsel James Orengo had to say about the technology company Safran Morpho and the printing company Al Ghurair.
We have said that we are not afraid for another election. In fact, the campaigns ended and we are ready to go for the ballot. But we have said that we will not go to an election until the IEBC rectifies all the mistakes which have now been confirmed by the court until those individuals who are responsible for these criminal acts are brought to book, removed and prosecuted. Then we are ready to go for elections within 60 days. We also have said that the KIEMS system that was used to manipulate these results must be rectified. And that we have issues with a company called Safran Mofo, which was hired to provide those services. As you see, the court found the IBC and the service provider were in contempt of court. They were not able to give access to the servers as ordered by the court. Why? Because they were hiding something. This has been confirmed. The court also found that the forms that were used in recording the results were forgeries. They did not come from the printer. They did not bear the security marks which were required. We therefore have also issue with a company called Al Ghurair, which was contracted to print the ballot papers and the other materials used in these elections. So we are therefore saying that we want another contractor to be appointed. Time is available for all this to be done.
The country may be bordering on a constitutional crisis of grave proportion. A constitutional crisis in the sense that the powers that the president would normally enjoy were extinguished very substantially on the 8th of August 2017. And after the 8th of August, he was exercising temporary powers of incumbency. And the danger that we now find ourselves in is that if the elections are not held within 60 days, then he will not have the constitutional authority or legitimacy to continue to be in that office. If you read the Constitution purposively and have a constructive interpretation of the Constitution, Articles 138 to 140, you will find that the president, when not constitutionally in office, there would be a requirement that you have an acting president who is not the incumbent president until an election is held. So this particular constitutional crisis that we are getting ourselves into must be resolved as quickly as possible. And that can only happen if we have an election conducted in accordance with the Constitution. And the IBC is not going to run away from it because the court has spoken very loudly that they cannot conduct any other election except an election held and conducted within the provisions of the Constitution. And they said that if the IBC does not do that, if another petition is brought before them, they will make the same decision.
All right, that there is NASA lead counsel James Orengo as well as NASA presidential candidate Raila Odinga. Let's begin first of all with the sentiments of one Raila Odinga, because James Orengo's sentiments are a whole other ballgame. Raila Odinga, they're detailing they want a new contractor or somebody else contracted to print the ballot papers, but perhaps again a new technology firm to also carry out the transmission of results. Honorable what Raila Odinga says is enough time to do this, but do we really have enough time?
We do. If there is enough goodwill, we do have enough time. You remember in 2013, with less than 60 days to the elections, we did contract I think it was a Canadian or French firm, to provide us with the electronic material. But having said that, this is my personal view, not the coalition's view. If the elections were to be conducted in strict compliance with the law, and the Supreme Court has said that you can only conduct another election in strict compliance. If they do that, if you ask me, you don't need another supplier, you don't need some other person to do the ballot papers, and you do not even need to change the IEBC. Not now, we can revisit the issue after. But remember, this is an IEBC that has already been indicted by the Supreme Court and said they so totally mismanaged the process. And so we must create a distinction between micromanaging IEBC and holding them to accountability. They are two different issues, and IEBC is a constitutional organ which under Article 10 is bound to respect the Constitution. So the questions of transparency are important. So as we try to say, what do we do, where is the boundary with IEBC, we must remember that as citizens and political players, we have a duty to hold them to account.
Honorable Kioni, the demands that have been labelled by the opposition, especially in IEBC, have been termed largely as micromanaging, largely as, especially when Raila Odinga says the election will be conducted on NASA's terms, and many thought that shouldn't be the way the opposition is speaking. But do you agree that this is about holding the commission to account?
He seems to have walked away from those statements that I think were unfortunate. When you say elections must be held as per NASA demands, then you see that's where the problem is. But if holding them to account, ensuring that the process is accountable, is transparent, that I believe it is in the interest of each player or every player who is party to this. But I think it is also important to dissect and get clearly. Justice Maraga went over a paragraph twice to make it clear to all of us that they never found any of the persons, either in the names of commissioners or staffers, to have been criminally liable. So that when we say that they must be prosecuted within the time before we hold elections, again, that was not in the findings of the judges, and it was not a recommendation from the judges.
Right.
When you then say that, I think the other thing that he said, that they were found, when you say that IBC was in contempt of court orders, I think it's also important to remember, even when an individual is said to have been contemptuous of a court order, you are given an opportunity to be heard. It's not you have to go to the dock and say, is it that you failed to comply with the order, or is it that the order was not compliable with, if there is such English word.
Right.
So I think it is important that we differentiate and make sure that we are not micromanaging IEBC, but we want to hold them to account. And this is where we politicians must really work to remove the suspicion that has already been created, so that we can say, this is achievable, this is not achievable. In whose interest is it to get the country into a constitutional crisis?
All right, gentlemen.
And I don't I don't want to say, but I heard similar statements from Lego during the 10th Parliament and from Professor Nyang'yo, and those statements are the ones that eventually gave birth to the Nusu Mkate.
Right, and I want us to focus on that, what James Orengo had to say just before we wind up. We only have about 5 minutes or so. Where does the law begin and where does politics also stop in terms of this constitutional crisis that the country is being warned about? Because according to the Jubilee side, if there's no election within 60 days, President Uhuru Kenyatta will remain president until another election is held. But listening to James Orengo there says, if 60 days have lapsed without an election, we will need an acting president who is not the incumbent president, and that will throw the country into an even deeper constitutional crisis. Let me begin with you as you wind up, Honorable Kioni.
According to the judgment, the majority, what happened on the 8th of August 2017 was nullified. It's like nothing happened. We are going back afresh. Meaning the president went back to his original position, where he's a president until another one is sworn in. So even talking about limiting his powers, I do not think it arises. And two, even if you read, I think it's Article 137, which says that in the event of presidential powers being limited, the president may not perform the following function. The word is may, not shall. meaning that the Constitution must have contemplated some circumstances within which the president will still be allowed to do all those things. Meaning that we do not have a temporary presidency. There is no provision in the Constitution that calls for another president from somewhere who come and sit in the office while we do something else. That is not there in the Constitution. It is some thinking that I can see coming from Malengo, and you'll pardon me for thinking that it is actually a way of getting to manage the government together as opposed to allowing the Kenyans' will to be exercised through the ballot.
All right, Honorable Oluoch, what is your interpretation of this? Because many say, even as we speak, the powers of the president have been diminished, so to speak.
Within the meaning of Article 140 of the Constitution, once a general election takes place, you can only have one of two things. Either a president-elect who becomes sworn in if there is no challenge to the election. The reverse of that is that there is a petition filed and the person exercises temporary powers of incumbency. Now, Uhuru was president-elect until a petition was filed. So that is out. That means he has already departed from president. You depart from that safe place called presidency before an election. After an election, you're either president-elect, which he was for a period of time, or you become that temporary president and exercise temporary power of presidency during the time of the petition and pending the outcome of another election. There is no third place after that. If an election does not take place, Article 140 and the entire Constitution did not contemplate a reversal. Let me then end by saying this, that the Supreme Court ordered for a fresh election. Article 140 again is plain and clear. In howsoever they couch it, if an election is nullified, the persons who go back are the two people, that is the number one and number two, or the person who petitioned against the person who is alleged to have won. So there is no provision here that we are going to a fresh election. It is a rerun of these two people. And even if it was a fresh election, the Constitution has already departed from President Uhuru and gone to president-elect and then to temporary president. Mwisho wa reri, hakuna kitu ingine hapo, ati tutarudi back to president. So President Uhuru, at the end of 60 days, when we must do another election, ceases to be president, which he ceased to be president-elect, and ceased to even exercise the temporary powers of presidency. That's why we are saying, if there is no election, we are not talking about caretaker and nobody wants nusu mkate. Somebody else takes over until another election. Either it is a speaker or it is the Chief Justice or such other persons as the world may decide to try and arbitrate. But Uhuru will cease to have been president.
As the world may try and arbitrate. Remember in 2008, the world came and arbitrated and produced a nusu mkate. President Uhuru ceases to be a president the day he hands over to another president or the day the will of the people allows him to continue as president.
Read Article 140.
That is the Constitution.
Read Article 140.
And also, the words, again, the operative word is may, not shall, in terms of the duties or the work that he can do. The functions that are taken away from him is the operative word is may not perform this, not shall not.
All right. Thank you so much, gentlemen. Very differing interpretations of the same law, which is why perhaps we're being told we will be looking at a very deep constitutional crisis. But thank you so much for speaking to us. Honorable Jeremiah Kioni is the Member of Parliament from Ndaragwa constituency, as well as Honorable Anthony Oluoch, Member of Parliament, Mathare constituency, trying to break down the analysis of the Supreme Court verdict issued by the Supreme Court judges yesterday. This is a State of the Nation discussion on Morning Express. At about 19 minutes to the top of the hour. We take a short commercial break. When we come back, we'll be sampling your thoughts on social media, as well as taking a look at what's making headlines in international news. Stay with us.